Thanks again to everybody that came. We are, as Christine, my assistant, mentioned, we are doing, this is our first immigration seminar. The purpose of it being that we, with all the immigration news that has been, popping up every day, there's been also a lot of confusion, a lot of misinformation that's been circulating as well online. So the reason why I wanted to have this seminar was to clarify some issues that are going on in the news, give a clear understanding about different options that people can have. I know a lot of people have family and friends who want to come from overseas. So it is very important to share the right information, direct them to the right websites to go on. So that's the purpose of today's seminar. So I do hope that it does resonate well with everybody, people who are viewing this on Facebook Live. They can share it with their friends and family, and that information can get spread for a number of good reasons. So everybody can come here the right way. Before I begin, I wouldn't be a lawyer if I did not have this disclaimer. The purpose of this seminar is for informational purposes. It's not a attorney-client relationship. I'm not your attorney yet. So this is all the slides that you're going to be seeing today are just very general information. Everybody's case is very specific to them. They have specific details. So any attorney that needs to review a case needs to look at those details before they can give advice. So this is not legal advice. This is just legal information, and that's the difference. So I just needed to remind everybody that if they do have a specific case, they do need to call my office and discuss it with me personally. Okay, let's move on. A little bit about myself. If you do not know me, my name is Sedki. I am an immigration specialist in immigration law. I have two offices, one in New York, in Long Island, and the other in Paterson, New Jersey. Like I said, I specialize in all areas of immigration in front of the USCIS offices. Even though my licenses are in New York and New Jersey, because I'm in federal practice, I do represent people from out of state as well. So I have clients from all around the United States. I do have clients overseas, so I do represent them in front of the US embassies worldwide. I also represent people in deportation proceedings, people who find themselves in removal proceedings before immigration courts. Our office handles that as well. So bond hearings, asylum cases in the court, of that nature. So I've been doing this for almost 10 years now. I love what I do. I deal with a lot of people from around the world, so that's one of the perks. I get to meet people of different cultures. It is what I do. So it's important that if you do speak to any attorney, not just my office, just make sure that they are very well versed in immigration law, because it's a very complex area of law. So that's a little bit about myself. Christine, you met Christine earlier. She is my legal assistant and my right side all the time. We also have Joseph, who's our paralegal that's in the Paterson office, Arabic speaking, Christina Spanish speaking, and they're both each learning the other language, which is really nice. So we'll be in full force as of 2020. And Catherine is also here. She's our administrator for the office, and she also handles billing. So I have a wonderful team, and they're all here with me tonight. So thank you, guys. Thank you. Okay, so let's begin. You were given an overview of some of the topics that we're going to be discussing today. I do talk very fast. We're going to try to get through all these slides tonight since we had a little bit of a delay in the beginning, but these are some of the topics that tend to, there's questions always being asked about these topics. So we're going to start with just some key concepts for immigration. The difference between non-immigrant and immigrant visas, green cards, of course, and naturalization, the new public charge rule that just came out a couple months ago. And then later on in the program, we're also going to have a guest speaker talking about crimes and immigration, and of course, asylum, which is always a hot topic. So let's begin with the essential immigration concepts. I always find that it's a challenge with a lot of my clients that terminology is always difficult to understand. Do you hear the coined phrase of foreign national or an alien or an immigrant. Like, they're all synonymous in its way, but they can actually mean different things in different contexts. So it's also important to know what the distinctions are. We're going to start with the first one, being a citizen and a foreign national. It's important to understand that anybody who is not a citizen of the United States is subjected to immigration law, meaning that even if you have your green card, okay, you are not afforded full protection under the Constitution. So as a person who is visiting the United States, who's here as a non-immigrant, and like I said, anybody who even gets their green card, okay, still is going to be subjected to immigration law. Okay, so there are people who live their entire life being green card holders and they never think about naturalizing, but that can actually land them in major problems with immigration law, which nobody ever thinks about it. And we'll talk about what kind of problems later on in the program, but you know, certain things like criminal activity could actually land a green card holder into deportation and deny them citizenship even. So the next key distinction that is important to know is immigrant versus non-immigrant intent. A lot of people do not know when they go to a U.S. embassy abroad that when you walk in and you try to get a visitor visa to the United States, you're already presumed to want to come and live and stay in the United States. This is what the officer is actually thinking. So if you're going in there and you say, yeah, I want to go visit the United States or I want to study, the burden is actually on you to prove that, because the officer is actually thinking this person is going to go and not come back. And this is why a lot of people actually get denied visitor visas to the United States, because it's presumed under immigration law that you're coming here and not returning. So it is up to you to be able to prove what your non-immigrant purpose means. A non-immigrant, just to define that a little bit more, means that you're coming for a temporary period of time for a specific purpose. So I'll use the B1, B2 visa since it's commonly used. You're coming here for leisure, you're coming here for a vacation, you're coming here for a business meeting. A student would say, no, I'm coming here for a temporary purpose to study in the United States. So it is up to the person, the individual who is applying for a non-immigrant visa, to prove their intention when they are going for that visa, okay? There are certain visas that are dual intent, meaning that it could start out as a non-immigrant intent and eventually become an immigrant intent. And what is immigrant intent? It means that you are intending to stay in the United States and live here. So we will talk a little bit more about different kinds of visas, but an H-1B, for instance, which is an employment-sponsored visa, that could be a dual intent. You can actually come here saying that you're coming here to work on a temporary basis, but that H-1B can eventually turn into an employment-sponsored green card, okay? So a very, very important thing to know. People just think they can walk into a U.S. embassy and just they'll get their visa. It's not that easy. There's work that needs to be put in. I always try to tell people before they go in what needs to be said, what kind of documents need to be provided and shown so that you can successfully obtain that visa. Okay, this is another very important distinction that people need to know. What's a visa and what's a status? It's two different things. So again, I'm gonna use the B1, B2 visa as an example because it's commonly used. When you are given a visa and the passport at the U.S. Embassy or the U.S. consulate, they give you a visa in the passport for 10 years, okay? That doesn't mean that you can come into the United States and stay here for 10 years, okay? There's a difference. When you come through the airport and you tell the officer in the airport, which we will have an officer later on today, when you tell that officer, I'm coming here to visit the United States, he says, okay. So he stamps the visa and the passport for a maximum duration of 6 months. So he says, you're allowed to stay here for 6 months, but you have to leave at the end of those 6 months. So a lot of people confuse those two concepts. They say, oh, my visa's good for 10 years, I can stay. No, you can only stay for what that date is on the stamp that the officer gives you in the airport, okay? Now, a long time ago, that stamp used to be in there, and that was the only source. They used to give you a little card in the in the passport, and that was your source to know how long you can actually stay in the United States. Now everything is done online. So the first thing that I do when clients come to my office and they show me their passport and they show me the stamp, the first thing that we do is we go online to verify if that date that they put in the stamp is the same as what is online. And believe it or not, a lot of times there is a discrepancy between the two. Okay, so an officer might actually have a discussion with a person coming in and say, well, I don't know if you're really gonna stay, here just, for 6 months. I'm gonna give you 3 months instead. So the date on the online I-94 website will say 3 months. Meanwhile, the one on or vice versa, So it's very important to verify that information. Don't just assume that you have the 6 months. Okay. So that's what stay means as opposed to the visa. There's a difference in the two. Okay. If I can get this to work. Okay. All right. So what happens when your non-immigrant visa is for a certain duration? Okay. Once that time has expired, once you know that time, that 6 months time, or if it's an H-1B, it could be for 3 years. Once that non-immigrant status has expired, you have to know how to extend. One of the biggest pitfalls in immigration is that people overstay their non-immigrant visa. And I'll tell you from now that if someone overstays and I've heard people say you break your visa, or but it's an overstay. And once you actually overstay your visa, the options that are in front of you, as far as being able to change to another visa, to be able to apply for a green card, all those become very limited. Okay, so again, one of the things that I always tell my clients is be very cognizant of when your stay is going to expire, because you will not be able, if your time expires, you won't be able to extend your stay. You won't be able to change to another status. You might not be able to apply for an employment opportunity. So everything kind of narrows. So the first thing we have to look at is, how do I extend? How do I stay here for a longer period of time? And I've advised my clients sometimes it's better to leave. Go home and come back again. You have a 10-year visa. It's better for you to maintain that lawful status. Don't accrue unlawful presence in the United States, because then you really don't have many options in front of you. Okay, it'll either be like a marriage or asylum. Okay, but we'll talk about that a little bit later. So changing of status, extension of status, adjustment of status. If you are planning in extending your status, okay, if you're here on a visitor visa, you want to make sure you do that well ahead of time. You can't come the last day and then decide to file the paperwork. So I always tell people at least 45 days ahead of time. That gives sufficient amount of time for the immigration to accept your application and start processing. Okay, so that's as far as non-immigrant. Now, again, you always hear about the B1, B2 visa. That's a commonly used one. ESTA is another program for people who have they are citizens of certain European countries. The ESTA program, or the visa waiver program, you actually do not need a visa to come into the United States. They automatically get a 90-day stay every time they enter. Okay, but again, if that person comes in on the visa waiver program and overstays the 90 days, then it could be very problematic, because they're given almost like a privilege to come to the United States. But ESTA is a very good opportunity if someone is from a European country. F1 students, again, we spoke about, this is for a duration of status, so depending on how long your program is for, that's how long the F1 student visa you're allowed to stay in the United States every time you come in. The H-1B, and all the ones that are coming after it, we're going to talk a little bit about. These are more employment-based. And the reason I'm listing them here is because a lot of people do not know that these visas even exist. Everybody's very fixated on, I want to come as a visitor, or I want to come as a student, but they have no idea that they have all these other letters that you can actually apply for. There's an O, there's a TN. TN visas, which I'll show on the next slide, is great for Canadians and Mexicans, people who are bordering the United States. The TN visa is actually for professionals in either one of the countries who want to come here and work with an employer. You don't even have to apply in a U.S. embassy. You can actually do it at the border. It's a wonderful opportunity for Canadians to come here, at least, check out the the market here as far as employment. There is a NAFTA list that does specify certain occupations. Not all occupations qualify for the TN visa, but if you go on the website and you check out the NAFTA list, you might be eligible to come in, and it's a great opportunity, especially for my Canadian clients. O visas, these are people who have exceptional ability in the arts, in business, in performing, it's an array, science. The O1 visa, again, not commonly used, and it's actually a very good opportunity if you have published works, if you're internationally renowned. We've done it actually we're doing it one for a belly dancer actually, so it's a great opportunity. The L1. The L1 and the E2 actually are more focused on businesses, people who own businesses overseas. So the L1 is if you own a business overseas and you're looking to make a branch or extend your business into the United States. So you're basically a parent company and you want to have a subsidiary of that parent company. You can actually send someone to manage that company or to run that company, and there's a connection between the two. So there's an L1A and there's an L1B. So depending on what you're looking for, you can qualify for either one of those. The E1 and E2, again, a great opportunity for business owners who want to come here and invest. It's an investment visa, okay? Now, the E2, for instance, you have to be from one of the treaty companies, meaning there is an actual agreement between certain countries and the United States to allow for an E2. So before someone could be qualified for it, they have to see if they're a national or a citizen of that country that's on the list. But the person can come here. They can invest a certain amount of money. There's no minimum amount. There's no specific amount that's designated by immigration. But if you have a certain amount of money, and let's say you want to buy a business, so what we would do essentially is to create a business plan on how much the cost would be for a business with the purchase and the renovations and et cetera, et cetera. We look at the total value, and then we see how much money that person has to invest. And what the immigration says is if that a percentage is substantially enough to invest and start that business, then they will issue a 2-year E2 visa, which is great. And it's renewable every 2 years indefinitely. So there's no limit on how many times. We've gotten a lot of calls about this E2 visa because it's a great opportunity. Now, you have to remember that these do not automatically lead to a green card, but it's a stepping stone. Okay, I'm going to talk a little bit about green cards in the next few slides. But I always tell people it's a stepping stone. You come in, you start the business, and it could lead to other opportunities. Okay, so these are just other non-immigrant employment options to consider or to tell your friends and family about. Okay, so adjustment of status, how to become a green card. All right, so we're going to move away from the non-immigrant visas. We're going to talk more now about the green card. And if I could collect a penny for every single client who calls our office and says, I'm in the United States, how do I get a green card? And they're ultimately disappointed when I tell them they do not hand them out in the airport. It doesn't work that way. So it's very difficult to get a green card in the United States. You have to work to it. Sometimes you have to just come on a different visa and then work your way towards the green card. But these are basically the ways that someone can get a green card. It's only these many. There's not that many options. But family-based petitions, which a lot of people do, they sponsor their parent, their spouse, marriage cases. This is, one kind of way to get a green card. Employment-based, if you have a company who is willing to sponsor you for a green card, this is a very good opportunity as well. It's a little challenging, I won't lie. It's because as an employer, you have to prove to the Department of Labor that there is no qualified U.S. worker to fill that position, and that is the reason why you need a foreign worker. So it is very challenging, and the person that you're trying to sponsor has to have very specialized qualities that can fulfill that position in the company. Asylum, which we will talk about a little later. I will be talking specifically about the requirements for asylum, but essentially if you do get approved for asylum, 1 year after that approval you can apply for a green card. So it's a great opportunity for those who have suffered persecution in their country. The EB-5 is an investment visa just like an E-2. However, this one does result in getting a green card after 2 years. The investment visa requirements were 1 million for an investment. So if you invest 1 million in a busy city, then you can qualify for the EB-5. 500,000 if it's a more rural, or what they call a TEA, or a targeted employment area. So if they're looking for businesses in a particular area, then it's considered a TA. So it's 500,000. They are changing the rules as of November 21st. So now the amounts are going to change from highest being 1.8. The TEA areas are going to be 900 and 900 and 1.8 million. But that's for the investment visa. The visa lottery, which is held every year. That's, of course, if you get selected. Good for you. You get to come here as a green card holder. VAWA is, again, not a very popular option, but it stands for Violence Against Women's Act. And this was legislation that came out to help spouses. I won't say just women. It'll be any spouse who is the victim of cruelty, abuse, any kind of violence in the home, domestic violence. So if you are the spouse of a green card holder or a U.S. citizen and have been subjected to that kind of cruelty, you can actually self-petition for VAWA, which would eventually give you a green card. Am I talking too fast? Okay. Okay. So just to talk specifically about what a green card essentially allows you to do in the United States is that you can live and work here permanently. It's the ultimate dream. It's what everybody looks to get, because it is, the way to get your passport eventually. So the green card process it could be employment or family-based, as we discussed. And I will discuss also later that it's not forever. It could actually be abandoned, and it could be also taken away from you. So it doesn't give you all the protections of a citizen, but it is you do get a lot of privileges being a green card holder. Now, there are different ways of applying for the green card. Some people have done it in the United States, and some people apply for it overseas because they don't have the option of coming here and doing the green card process from the United States. So the 485 is the form that is typically used here among other forms, but the I-485 is the form that is used for green card process with USCIS. So that is the form. They constantly change it. They're making it more detailed. We'll talk about that later on as well. They are always asking for more information, especially about your financial situation. So it's very important, and this is across the board with all different forms, is that if you are doing it on your own, then you need to check the website regularly. Don't assume that a saved one somewhere out on Google is the right one. You have to check on the USCIS website to make sure that it's the updated one, because they will actually send your form back if it's not. Okay. I'm going to shift to applying for green cards through consular processing. And what that means is consular processing is the method in which you would apply for a green card through a U.S. embassy abroad. So if you are applying for a relative, I'm going to talk about family sponsorship because it's a little bit easier. If you're applying for a family member overseas, you do begin the process here. Okay, it starts with the United States Citizenship and Immigration Services. So USCIS is the first part of it. It eventually goes to the National Visa Center, which is the NVC. Okay, and once they collect all of the documentation, it then goes to the U.S. Embassy in that person's home country. Okay, it's a very complicated, very lengthy process. Nothing happens overnight because it does go through all these different agencies. And contrary to most believe that all of these agencies are all connected and all have the same information and all talk to each other, they don't. What happens is a lot of times documents get lost, they need to be resubmitted, and people are like, why? It's all immigration, they should all be connected, and it's not. It's not a perfect system. They're trying to make everything electronic so that we upload documents just once, but it's not the way it is now. It's form filling in the beginning, then it gets uploaded in NVC, and then you just hope that the whole file will arrive at the U.S. Embassy in one piece. But Christine will tell you that never happens. So what ends up happening is they will ask for documents, many times. Now, if you start the process in the United States and it's going to be continuing through the consular processing at the U.S. Embassy, I have had a lot of people tell me, well, my case is going through the green card process, so I'm just going to stay in the United States until that happens. Well, you can't do that because, as we said earlier, if you are here on a non-immigrant visa and that time has expired, you do have to leave, continue the process overseas, okay? Unless you have some alternate way of staying in the United States and doing the green card process from here. But otherwise, if you choose one, you just gotta stick with it, okay? Some people have started consular processing, like if you're filing for a sibling, okay? And we'll talk about processing times, but it's a 13-year wait. So a lot can happen in 13 years. So some people start the I-130 process, but then by the time the 13 years passes and the green card is ready, it's, the priority date is current, that person is here doing something else. They're here on a work visa, they're here on a student visa. At that point in time, because they're in lawful status, they can actually change the process and make it do the green card process from in the United States. So again, it's all case specific, but again, you have to maintain your status at all times in order not to be rejected and have an admissibility bar, which we'll discuss in a bit. So let's go to the next slide. Okay, so family-based immigration. Again, we're continuing with consular processing. Immediate relatives, when they say immediate relatives, they mean spouses, parents, and children under the age of 21. Those are immediate relatives. Those have no quota. So if your parent comes, or if you have a child here that's under the age of 21, or you just get married and you want to apply for a green card, you don't have to wait. There's no wait time. That's what the quota is, essentially. But if you're a green card holder and you're trying to apply for your spouse or your child, or, you can't do your parent, so it's just the child or the spouse, there is a wait time, okay? I'm going to go more into that in the next slide. U.S. citizens who want to sponsor their children who are over the age of 21, they have also a quota they have to wait. So everybody has to wait their turn. The only ones that don't have to are the immediate relatives, okay? So we're talking about priority dates. So I'm going to show you. Okay, so these are the preference categories, okay? These are the 4 categories that you are, 5 actually, that you can find yourself in if you're doing family sponsorship for someone abroad, okay? So the F1 category are the unmarried sons and daughters of U.S. citizens. That means the ones that are not 21, under the age of 21. These are over the age of 21. So, and they have to be, these are unmarried, okay? We'll talk about married after. That's on F3. And married sons and daughters of U.S. citizens are F3, so they have a different processing time than F1. Second preference, spouses and children and unmarried sons and daughters of permanent residents. Those are broken down. So F2A are the spouses and children of permanent residents, okay? Now F2A, just this summer, miraculously became current because this was on a 2-year wait. And all of a sudden, it became current, and they said that if your priority date is before August of 2019, you can file your green card application. So that one actually, and I'll show that in the next slide. The unmarried sons and daughters who are 21 years of age of permanent residents, that's still on a wait time. So if anybody you know is in an F2A category, then they actually can file their green card for their spouse and children. And then the last category, the F4, are the brothers and sisters. That one is obviously taking the longest amount of time. So I'm going to show you on the next slide what the processing times look like and where you can find, if I can actually do it. Okay. So this is what a visa bulletin looks like. This is on the travel.state.gov website. This is what the bulletin looks like for first category is basically every country besides those 4. So China, India, Mexico, Philippines have their own processing times because of the volume. And then, but I'm gonna direct your attention to the first, the the first column. So how do you read that? It's January 15 of 2013. Again, if F2A is current. So 2014, 2007, 2006. Okay, so that's how you read it. So you compare which preference category you're in, and then you go to the this visa bulletin, which again is updated every month. It doesn't change drastically, but it does change. So you keep referring back. When you get the I-130, the first application that is approved, it has a priority date. That's the date that you're going to be comparing to this chart to know where you are. Are we ready? Are we getting close? Now, to make matters even more confusing, on the website, there's a second chart that looks exactly like this, but the dates are a little bit different, and they call them filing dates. So if you're getting close to this date, the filing date might actually be earlier. So if you're getting close, that let's just say that November 22nd, 2006, you might actually have a filing date of February 2006. So you can actually apply much earlier to kind of jumpstart the process. So again, there's two charts that you would be looking at, but the first thing is to know which category you're in and to know how far you are from it being current. Okay? So that's the chart. There's another one like this for employment sponsorship, but we're not going to go into that today. Okay, so and if I remind you, Christine said earlier, if you do have any questions, during this, please write them down. We're going to answer all those questions at the end. We'll give enough time. I know this is a lot of information that I'm throwing, so feel free to just jot them down. Okay, so going back to green cards, again, it's a wonderful opportunity if you do get approved for a green card. But there are a lot of ways to get denied a green card, and this is where consulting with an attorney before you apply for a green card is very important for the basic reasons that small mistakes that you make. If I can tell you how many people come to me after they've applied because there are mistakes that are made, or they forgot to put certain information, or they claim they forgot to put in certain information, and this can eventually result in a denial of the green card. It's also very important to know that in a lot of the interviews that I have attended recently, I have noticed from USCIS officers that while they're conducting the interview on their screen, they have all the information that the applicant has filled out at the U.S. Embassy in their country when they're filling out the visa application. So they're not just looking at your green card application, they're comparing it to the information that you provided in the U.S. Embassy. So God bless technology. They're able to now connect everything. They even have access to CBP records. CBP are those officers who are in the airport when you're coming in and you're telling them. They're documenting everything in their computer. So USCIS now has full access to the U.S. embassies and consulates as well as the airport CBP officers. So when you are doing your green card application, do not assume that they are not going, you should assume that they have that information and make sure it's consistent. Because I just had a marriage case where someone in the country said that they were married, and then when they came here, they got married to somebody else and said, this is the first time I'm getting married. So there was that conflict, and it was a little hard to overcome because that was a misrepresentation. It was fraudulent. So this is fraudulent, lying on applications or not representing the facts correctly can be a basis for denial. Criminal convictions, not all criminal convictions, but there are some, and we will talk about that later, that could be a problem. So you need to consult with someone to know if there are consequences before you apply. Unlawful entry, this is basically people who have entered without inspection, who have not entered the United States with a visa. So they just basically crossed over, some of the people that are coming through the southern border, those are people who are entering without inspection. If you don't enter and you're not inspected, you can't adjust status to a green card holder. You have to apply for something called a waiver. Again, we will talk about it in a little while. Prior deportation orders. If you've been in immigration court and you've been ordered deported by a judge, or if you've had any court proceedings, you really need to have that assessed by an attorney before you can apply for a green card, because being deported by an attorney being deported by a judge, an immigration judge, and never leaving the United States, that has its own consequences in itself. They can initiate the deportation order, and it could be even worse because you'll be barred forever from returning to the United States. So so these are some of the ways, but it's really important to know this fact, is that you need to know that the information you're putting on that is accurate. People don't even read the questions. I mean, there are security questions on the application. People have no idea what is being checked off as yes and no. They just, no, I've never been convicted of anything. You know, if you've had military training, which is common in a lot of countries, you get military training, or you've had weapons training, which is routine. This could be affected if you're not saying it on your naturalization or your green card application. So you have to be thorough, and you have to make sure that someone is reading back the application to you if English is not your first language. Okay. Let's go to okay, the public charge rule. All right, so there was a lot of panic when this rule was introduced back in August. So the public charge rule is just something that came up in the news recently, and what it is, it's a provision of the Immigration and Nationality Act, which is like the law, the immigration law itself, and it states that a person is inadmissible if they're likely to become a public charge. Okay, now this provision has been in immigration law for the longest time, before I even practiced immigration law. However, the administration right now and USCIS have decided to reinforce the public charge. They want to start to having it as a criteria before somebody can actually get a green card. All right, so what is a public charge, just to define it a little bit? It's someone who will or has used a government benefit for a period of 12 months in any 36-month period, okay? So basically, the government is saying that is as a non-immigrant, okay? And I'm going to tell you who this applies to. Maybe I'll just show you the next slide. Hold on. If you've applied for a government benefit when you were not entitled to it. So as a non-immigrant, if you're coming in as a visitor or as a student or as an H-1B, if you're not buying your own insurance, what the government is saying, you're not entitled to ask the government for Medicaid. Okay, so but a lot of people unfortunately come and they do apply for it. All right, so you know, food stamps, and I'll show you a list of which benefits have been considered in the public charge. So what they are arguing is they're saying that if you're not entitled to this, and approving you for a green card, you will later become a burden on the government, financial burden on the government, then we are not going to approve your green card application. So this is, again, this is one criteria that they're looking at. It's not that, oh my God, I got benefits, I'm never getting a green card. And if I could tell you the number of calls that we got, just sheer panic, like, oh my God, I applied for food stamps like 10 years ago. It's not like that. They are looking at to see if this person eventually, once he becomes a green card holder, that he's going to just keep asking for government benefits over. And people's situations change, so they are just looking at this one thing. So the next one, so I made a chart about which benefits are included in the public charge rule. So the ones that are on the left-hand side, these are what they are saying, that if you are currently getting them, or if you have used them for at least 1 year in the past, these can be used against you. Okay, so food stamps, non-emergency Medicaid. Okay, the ones that are on the right side, those are the benefits that they said they are not going to consider for green card applications, which is Medicaid for children and pregnant women. Okay, so that's a big one, and a lot of people have actually received Medicaid because they were pregnant and they went into a hospital, they gave birth, they never paid for it. Okay, so they are not actually going to, that's a huge one that people were very worried about, because it was very popular. WIC and state-funded Medicare, those are not included. However, these will be. Okay, And it's also important to know that it's not affecting everybody. It's not people who are applying for citizenship. This is people that are applying exclusively for the green card, or they're looking for adjustment of status. So people who are doing consular processing, this will also be a concern. So if they've been here on a visitor visa and then they went back and then they're applying for a green card, yes, these are factors that could be considered. Okay, so the people that are who are not affected by this, again, are on the right side. Asylum seekers, people who are victims of serious crimes, juveniles, temporary protected status. These people, even if they're applying for green card, would not be affected by it. Okay, so with that said, this rule was supposed to take effect as of October 15th, which just passed. Leave it to the lawyers. There were a lot of people that were angry. They said this could be discriminatory. This could be, you know, a big problem. So they filed a lawsuit, and there are federal judges who actually did a court injunction on the same day, on October 15th. The form that was supposed to come out, which was the I-944, it was published on the USCIS website October 15th. It was gone. So as of right now, nobody who's here or overseas has to do anything differently in the green card process. Okay. However, we do not know when it might come back. It might not. They're going to litigate this until, you know, they come to some kind of, you know, I guess an agreement that, you know, where they can use certain things, and making sure that it's not going to be discriminatory to any immigrants. So as of right now, you just carry on doing what we were doing before. There is a new 485 application that is coming out, so that's the only thing that they did change. But as far as the public charge form, that is not being used at this time. So that's some good news. All right. Okay, so like I said, in the public charge, if it does come back, just so that you know, they are going to, when you go to an interview, they're going to be looking at a series of things. One of them being, you know, your employment status at that time. So maybe you were, you know, unable to work before, or you needed some assistance, but now you can work, your health is better. They're going to look at family size. How many people are you going to support? Okay, when you apply for a green card, there's an affidavit of support. So somebody basically has either the spouse or the family member or a third party will say, I can support this person in their process of getting a green card in case they go into a hospital or they, you know, have all of these expenses. As an affidavit of support sponsor, they are willing to take on that expense so that they make sure that the green card holder does not go and ask the government for benefits. So one of the things they're going to be looking at is who signed that affidavit of support. And I have to say that this is a very, very crucial subject, because I have had clients who have random people signing the affidavit of support. They don't even know who they are. And they say, oh, this person can do it. You know, there are criminal repercussions for that person if they are signing something and they don't know who you are. So there's penalties. And then they also can pay them back. I mean, they'll have to pay back all, if the immigrant has racked up all of these bills, the sponsor will be financially responsible for paying all of those bills back. So it's very important that the person that you get in the affidavit of support, you know them, you have some kind of relationship. So that's something they're going to be looking at. And like I said, employment and age and health, all of these factors. So if and when the public charge rule does go into effect, it's going to require a very thorough evaluation on that person and what their situation is, so we can counter any benefits they may have received in the past. Okay, so I'm sure if this does come back, I'm going to be doing a seminar just on the public charge, because it's a lot of information. Okay, I'm going to move on to the hot topic of naturalization. This is essentially when somebody is, has received their green card and they are in the process of applying for naturalization. They're at that point. Now, again, people think it's a very easy form to fill out. It's done online. They fill out all their information and they send it. They pay the fee, which is not cheap. It's about $700. But the problem is that people apply for it without even knowing if they're eligible for it. Okay, it's not had my green card for 5 years, now I can apply for citizenship. It's not that easy. So on the next slide, I'm showing you what the eligibility requirements are. Okay, so one of the things is that you have to be 18 years or older. If you are under the age of 18 and your parent has received their citizenship, you don't have to actually apply for naturalization. You get something called derivative citizenship from the parent. So all they need is the parent's citizenship application, and they can go ahead and apply for a passport right away. So you save yourself $700 if you are under the age of 18 and your parent has naturalized, okay? You have to be a permanent resident for at least 5 years. If you got your green card through marriage, it's only a 3-year wait, so you actually can do it sooner than later. This is a big one that people don't know about. If you're applying for naturalization in a particular jurisdiction, you have to have lived in that state for at least 3 months. There have been cases that have been kicked back because they can't show their residence in that state. People don't know that, but it's actually one of the requirements. So if you're moving, you have to wait. You have to wait until you've lived there for at least 3 months. The next two, okay, is what we call continuous and physical presence. This one I'm going to spend a little bit of time on because this is one of the main reasons that naturalization applications get denied. Okay, continuous presence means that, let's say the 5 years that you're waiting for a green card, that you have your green card and you're going to apply for citizenship. In those 5 years, they said that you have to have lived continuously in the United States. So what does that mean? It means that no trips can be taken outside of the United States for more than 6 months at a time. Okay, and the reason they put that rule is because if you're living anywhere for more than 6 months, or you've taken a trip from outside of the United States for more than 6 months, it's more likely than not that you have a residence outside of the United States. Nobody stays that long outside unless they have a home there, okay? Now I can speak from a lot of my older clients, okay, who are retired, who get their green card, they go and they live in another country for more than 6 months, okay? The law states that any trips more than 6 months is a presumed abandonment of your green card, okay? It's pretty serious. They presume that you've abandoned if you have been out for more than 6 months at a time, okay? Now, if you've been out for more than a year, it's an automatic abandonment of your green card, okay? It's serious stuff. So when people come to me and they're showing me their trips and they've gotten like 7, 9, 11 months outside of the country, every one of those trips that is listed in that 5-year period have to be explained. So I'm working actually on a case right now where she spent 11 months in one of her trips, and she's an older lady, so she doesn't have too many ties to the United States. She lives with her son, you know. So we're now trying to counter the abandonment issue, okay, with her not having sufficient ties. And this is something that should have been looked at before she applied and not after, okay? So she essentially might end up getting denied. We're still working that out. But, you know, it's very important. She could have waited 1 year, kicked that 11-month trip outside of her 5-year period, and she would have been eligible to apply. But she prematurely applied, and she could actually, you know, lose the time and the money in applying for citizenship too early. So that's continuous presence. So they're looking at trips that are more than 6 months. Physical presence means that in the 5-year period, you have to have spent at least half of the time, 30 months, okay, out of the 5 years, have to have been in cumulatively. So we're looking at all the days cumulatively. So again, when we list the trips and we calculate all the days that you spent outside and how much is inside, you have to have at least 30 months, which is exactly 912 days. So if you don't have 912 days in the United States, you are not eligible for naturalization. Again, a big one that people end up getting denied for because they don't count their days in the United States, okay? So those two we always look at really closely. Now, being able to speak English and understanding the U.S. history, that's the exam, okay, the examination, okay? That's a requirement for getting naturalized, all right? There are people that have trouble with the English language, although that's not an excuse, okay? You have to pass those two tests in order to get naturalized. So there are exemptions, though. Okay, there are age exemptions. There are legal permanent residency exemptions as far as your age and how long you've been in the United States. Okay, I'll talk about all of that later. But there is age exemption. There's also medical exemption. If you have a medical disability that is preventing you from being able to study, learn. I have a client who has severe dementia. She cannot learn. It's not a matter of just she can't learn the English language. She really cannot retain any new information. So she has to get a certified medical exemption form. It's a form that's provided by immigration. It's got to be certified from a doctor that explains there are certain tests that have been administered and that person cannot learn any new information. If the USCIS accepts that form, okay, then the person will be exempted from both the English and the civics, okay? It sounds great, but it's extremely hard to get, okay? So you have to make sure that the doctor who is signing off on that form really knows what he's doing, okay? The last one being a person of good moral character. This is a very open phrase that really nobody has any idea what it means, even immigration attorneys. What does it mean to be a good person of good moral character? You know, I could say I'm a person of good moral character. Someone else might not agree. In as far as the immigration is concerned, there are certain criteria that actually makes someone a person of good moral character, which means you really have to have not done anything bad to anybody else in that 5-year period, okay? It's a very generic term. It's always up for controversy, okay? Us lawyers were always arguing with immigration on this because you know, there are certain things that might make a person bad, but immigration might say one bad criminal act and you're not a good person, you know, in 5 years. So again, when we're evaluating a case and I have someone who does have a severe criminal problem, I have to counter that with some good factors. He's a good person in the community. He's loved by his neighbors. We get affidavits. We get people to really show that he is, you know, he's tried to rehabilitate himself. I use a male, of course, not a female. But, you know, that person has really tried the best to rehabilitate themselves and is deserving of naturalization. But ultimately, it is the immigration officer who's interviewing in the naturalization to determine whether that person is a person of good moral character. And a lot of people do get denied just based on that one criteria. Okay. Okay. So continuing with that, so not having a criminal conviction in those 5 years could actually prove that you don't have the right moral character to be naturalized. Failing to pay taxes, this is a big one. A few years ago, USCIS and the IRS joined forces, and if you are not paying your taxes and you have back pay, or you're supposed to be on a payment plan and you haven't followed through with that, that can actually delay or essentially have your naturalization application denied. So if you are in back taxes, like you're not paying your taxes or you need to be on a payment plan, you need to do that before you apply for naturalization. Get on a plan. Have a letter from the IRS stating that you are paying them little by little, and they will actually allow you to naturalize. Okay? Like we talked about before, trips outside of the U.S. for more than a year. So if you're a green card holder and you know for sure that you need to leave the United States and be outside for more than a year, you want to let the immigration know that you're not coming back for a year. There's something called a re-entry permit that you should apply for, okay? It's a permission that is granted to the green card holder to leave for a year and be able to come back with no problems. Okay, but it is important to know that that 1 year is not going to be accounted for in the physical and continuous presence requirements. Okay, so all those days out are not counted for. However, it will not subject you to any problems in the airport. You'll be able to come back and you're preserving your green card without any problems with immigration. So again, a very important thing to apply for before you leave. Again, fraud and misrepresentation is always a big issue in getting denied for naturalization. So I'll tell you that in naturalization, the immigration officers are a lot more thorough than in any other process because they can open up every single file you've had with immigration since the beginning. So when you applied for that visa, when you came in, when you were a student, when you're, any violations along the way, they're going to have access to it and they're going to open it. So the whole file is there in front of them. So again, we want to make sure that there's no misrepresentations, there's no conflict of information, and if there is, better to clear it in the beginning than wait for the officer to find out. Okay, that's what I always tell my clients. Tell me, or be straightforward about it from the beginning so we can see how we can actually resolve it and get you naturalized. Okay, so these are just some of the ways, aside from, of course, failing the examination, but these are some of the ways that most people end up getting denied for the passport. So very important. Get your case analyzed before you jump and just apply for naturalization. Okay? Okay, so how are we doing with time? It's 8 o'clock? All right. All right. So we're going to take just a quick 5-minute break, okay? I have, there's a few organizations that are here that I wanted them, just give them a few minutes to present. They have very good services to offer. We actually have a representative from USCIS who was very gracious in giving us some of her time so she can answer. She's got stuff, handouts out there. But there are also two organizations who are here. I do have to mention them by name. I hope they can hear me from outside. But Ms. Carmen Guerra, she's from the Alliance of Positive Change. She will tell you what her organization offers. Aurora Kasab is from the New York Historic Society. They actually offer naturalization classes for free. So if you're looking to study for the exam, they have a free course that they're offering. So I'm going to actually have them come and we'll take a short break if anybody just needs to stretch. And then I'm going to have them come in and talk about their organizations, and then I'll be back. Okay?